Good morning, ladies and gentlemen. This is Kunal here. Today we are going to read about the Judiciary, Chapter 23. Chapter at a glance. The Constitution of India is a federal constitution, that is, it provides the division of power between the central and the state government. There is a single integrated judicial system in India. It is organized on pyramidal form. At the apex of the entire judicial stands the Supreme Court of India. Immediately below the Supreme Court are the various high courts, and below them are the subordinate courts in each state. The Supreme Court is the highest judicial tribunal in India. It consists of one Chief Justice and 30 other judges. They are appointed by the President of India. A judge continues to remain in office until the age of 65 years. It may be removed by the President of the Republic on a report of Parliament on grounds of approved misbehavior or incapacity. The Supreme Court has originally appellate and the advisory jurisdictions. Original jurisdiction. The Supreme Court has exclusively original jurisdiction in any dispute between the Government of India and one or more states. Second, the Union Government and any states or states of the side and one or more states on the other. Third, two or more states if the disputes involves a legal right. First, appellate jurisdictions. When the matter is constitutional, an appeal lies to the Supreme Court when the High Court certifies that the case involves a substantial question of law as the interpretation of the institution. Second, in civil cases, as appeal lies to the Supreme Court when the High Court certifies that the case involves a substantial question of law of general public importance. In criminal matters, one appeal lies to the Supreme Court when the High Court reverses the acquittal order of the lower court and sentences him to death. Advisory jurisdiction. Under the Constitution of India, the President of the Republic can refer to the Supreme Court any question of law or fact of public importance for its opinion, and the Supreme Court may report to the President in its opinions and thereon. And lastly, the Supreme Court may grant special leave to appeal from the judgment of any court of India. The Supreme Court is the interpreter and the guardian of the Constitution of India. It can annul the unconstitutional law and orders of the Union and the state governments. Judiciary has been provided with a writ jurisdiction for protection of fundamental rights of the people. Judiciary is provided with various powers which helps it to constitute as the guardian of the Constitution. Public interest legislation has been evolved as an instrument of social revolution that has helped in providing justice to the vulnerable and the downtrodden. The primary aim of PIL is to bring justice within the reach of the poor masses and give them access to the courts to obtain legal redress. Judicial activism offers that instead of judicial restraint, the Supreme Court and the other lower courts become activists and compel the authority to act, and sometimes also direct the government and the government policies and also administration. Judicial activism has arisen mainly due to the failure of the executive and legislature to act and due to the non-activity of the other organs of the government. The Constitution of India provides a high court for each state. The Parliament may, however, establish a common high court for two or more states and a union territory. Each high court consists of a chief justice and such other judges as the President of India. Many may determine from time to time. The judges are appointed by the President in Constitution with the Chief Justice of India and the governor of the concerned state. Every high court enjoys originally jurisdiction with the respect to revenue, its collection, cases of succession, divorce, and its appellate jurisdiction. It hears appeal from the lower court in cases targeting sale tax, income tax, copyright, and patent rights. The High Court is a court of record and its proceeding and discussion are referred to in future cases. A High Court can issue writs for the enforcement of fundamental rights or any other such purpose. The High Court is empowered to interpret the Constitution of India. It can review the laws of the state legislation and may declare them null and void if they go against the provisions of the Constitution. Again, if a high court is satisfied with a case pending in a lower court involves a substantial question of law as to the interpretation of the constitution, it may dispose of the case itself. In text question 23.1, what is the present number of judges in the Supreme Court including the Chief Justice of India? The present number of judges in the Supreme Court including the Chief Justice in India is 31. How does the President of India appoint the judges of the Supreme Court and other than the Chief Justice? The President of India appoints the judges of the Supreme Court after consulting with such judges of the Supreme Court, and he or she may deem necessary after consulting the Chief Justice of the Supreme Court. In actual practice, after receiving the opinion of the Chief Justice, the Cabinet deliberates on the matter and advises the President in regard to the persons to be appointed. The President acts on the advice and appoints the judges. How is the Chief Justice of India appointed? Mention the case which was an exception to the accepted convention. The senior most judge is usually appointed as the Chief Justice of the President of India. This is a usual practice for appointed the Chief Justice. But there are an exception when the government appointed Justice A.N. Roy, pending 3 of this senior colleagues on 25th April 1973. Question 4. Why and when was a bill introduced to set up a National Judicial Commission? Answer. A bill was introduced in the Lok Sabha by the National Front government at the setup of National Judicial Commission in 1990 by the Law Minister Dinesh Goswami, empowering the President to constitute a high-level judicial commission for making recommendation for the appointment of the judges to the Supreme Court, other than the Chief Justice of India, Chief Justice of High Courts, and to the transfer of the judges from one High Court to another. Question 5. What are the grounds of which the judge of Supreme Court can be removed? A judge of the Supreme Court can be removed under the Constitution only on grounds of the proven misconduct or incapacity and on order of the President of India. In text question 23.2. What does the term legal right mean? The term legal right mean a right recognized by law and being enforced by the state for necessarily in a court of law. The right to access to legal advice, the right to silence, the right to fair trial are some of the examples of the legal rights. Question number 2. Which under circumstances can the Supreme Court has the power to transfer to itself cases from one or more high courts? Answer. Under Articles 139A, the Supreme Court may transfer to itself cases from one or more high court if any dispute is to be brought into the Supreme Court. It must involve a question of law on which the legal right depends or in the interest of the justice. Question number 3. Which article entitles the Supreme Court of issued writs for the protection of the fundamental rights? Answer. Article 32 entitles the Supreme Court to issue the writs for the protection of the fundamental rights. Question number 4. The appellate jurisdiction of the Supreme Court extends to which type of cases? The appellate jurisdiction of the Supreme Court extends to civil, criminal and the constitutional cases. Question number 5. Define a tribunal. A tribunal is a body of authority, although not a court, having all the attributes of a court, which has a judicial power to adjudicate of the question of law and fact affecting the rights to citizen in a judicial manner. In text question 23.3. Which court has the wider power to issue writs in the context of fundamental rights? The High Court has the wider power to issue the writs in the context of fundamental rights. Question number 2. Why is judiciary called the protector of the fundamental rights? Indian judiciary is the protector of the fundamental rights of Indian citizen and the guardian of the Indian Constitution because it has been given power to protect, safeguard and uphold the Constitution and its various components. It can also empower to declare law null and void if it would find to be inconsistent with the Constitution. Besides this, the Supreme Court and the High Court can issue other directions and orders in the interest of justice to the people. Judiciary, through these writs and other available mechanisms, employ it to the best to protect fundamental rights and freedoms of the individuals particularly those provided in the Constitution. Hence, it is called the guardian of the Constitution and the protector of the fundamental rights. Question number 3. How is the judicial system of India based on the hierarchy of courts? The judicial system of India is based on the hierarchy of courts from the subordinates court to the Supreme Court. We have a chain of the courts that works at every level to provide justice. The common people can seek justice from lower level and can move to the higher court depending upon the complexity of the court. In text question 23.4. Question 1. What is the primary aim of public interest litigation? Public interest litigation or PIL is defined as the use of litigation or legal action which seeks to advance the cause of minority or disadvantaged group or individuals, or which raises issues of broad public concern by taking cases that can benefit disadvantaged groups or minorities rather than one person. PIL can be used to provide access to justice to those who are most in need of it and yet who find themselves furthest from it. Question number 2. What does the traditional Anglo-Saxon concept of locus standi means? Answer. The traditional conception is regard to the locus standi is that judicial redress is available to a person who has suffered a legal injury by reason of violation of the legal right. Question 3. Why is PIL called the sole instrument of the social revolution? Public interest litigation is a powerful arm of a legal aid movement in India. The trend of the public interest litigation, which during initial state Prof. Upender Bhaksi refers to call it as a social action litigation, which has opened new vistas of judicial activism and taking justice nearer to the common man. The Supreme Court and some of the high courts have shown deep interest in PIL cases with a view to the amelioration of the miseries and the hardships of poor litigants, who called out withstand the rigors of the conventional adversarial system of litigation, which mostly provides relief only a rich and a wealthy litigant, besides providing relief to poor and the needy litigants. The public interest litigation also provides an effective check against the governmental lawlessness and the careless and the negligent attitude to the executive official by making them accountable for their lapses or arbitrary acts. It is a very happy development in the legal history of the 20th century in India as it makes Indian judiciary an instrument of social justice for the welfare of the Indian people as a whole. Public interest litigation is a very helpful to the people in getting justice. It is resulted in the judicial activism and thus called as the sole instrument of the social revolution. Which two drawbacks of judiciary resulted into the judicial activism? Judicial activism merged only as a result of inefficiency or lukewarm efforts to provide justice of the judiciary system. Besides delay in the justice due to the technicalities in another drawback that resulted into the judicial activism. Question number 5. In which case the court has treated a letter as a writ petition? In Bandhuna Mukti Morcha on the Union of Indian case, the petition requested for a writ to be issued in the view to end of the misery, suffering and the helpless of these labours. The Supreme Court treated the letter as a writ petition and appointed a commission on inquiry and ordered the release and the rehabilitation of all bounded labourers. In text question 23.5. How does the President in India appoint the judges of the High Court? Answer. The Chief Justice of High Court is appointed by the President after consulting the Chief Justice of India and Governor of the state, and in case of appointment of judges. Other than the Chief Justice of the concerned High Court is also consulted. Certain requirements are required for the post of the judges of the High Court, and like he or she, first, must be a citizen of India. Second, have 10 years of service in judicial office, or third, have 10 years of experience as a High Court advocate. Question number 2. Mention any two functions of the High Court. First, answer. The two functions of the High Court are: first, the High Court have larger jurisdiction than the Supreme Court in respect of the issuing writs. The Supreme Court under Article 32 can issue writs only where a fundamental right has been infringed upon. but a high court under Article 226 can issue them not only in such cases but also where an ordinary legal right has been infringed upon, provided a writ as a proper is a proper remedy in election, marriages, and divorce cases. Second, High Court has also the power to call out for any record from the subordinate court to examine the orders passed by them. In exercising this power, the High Court seeks to ensure that the orders passed by the subordinate courts are legal and correct. Question number 3. Why is judiciary called the pillar of the democracy? The judiciary is called the pillar of the democracy as it stands firm in order to deliver justice for the sake of mankind. The Indian judiciary is independent and separate from the government and the legislature that provides correct interpretation to the constitutional matters. The judges of Indian court have maintained very high standards of judicial integrity with the emergency proof, judicial activism and its instruments like PIL to ensure public interest and promote welfare state. Terminal questions. Describe the composition of the Supreme Court with the reference of the appointment of the judges. Answer. The Supreme Court is the highest court of law. The Constitution says that the law declared by the Supreme Court shall be binding on the small courts within the territory of India. The Supreme Court was designed to make it final authority in the interpretation of the Constitution. Originally, there was a provision in the Constitution that there will be the Chief Justice and seven other judges. The number 7 was raised to 10 in 1956, 13 in 1966, 60 and 17 in 1977, 25 in 1985. Article 124 later in 2009, it was fixed at 31 judges, including the Chief Justice of India. The President in its appointing authority in the case of judges of the Supreme Court as provided in the Article 124A while making appointment of the Chief Justice of India. He may consult such of the judges of the Supreme Court and the High Court of India as the highest consider necessary while making appointment of other judges of the Supreme Court. The Chief Justice shall always be consulted Article 124(1) in addition to regular judges. If the President feels that the workload is heavy, he can appoint ad hoc judges as well. He is also empowered to invite retired judges to attend the meeting of the court. What are the grounds for the removal of the judges of the Supreme Court? Explain the procedure of removal. Answer. The procedure relating to the removal of a judge of the Supreme Court is regulated by the Judges Inquiry Act 1968. By the process of impeachment, there are two grounds of removal. First, proved misbehavior or incapacity. A judge of the Supreme Court can be removed from his office or by order of the President. The President can issue the removal order after an address by the Parliament, supported by a special authority of each House of Parliament, that is, with the majority of the total membership of that House and the majority of not less than 2/3 of the members of that House present and voting, has been presented to the President in the same session of Parliament for such a removal. The procedure of the Parliament for such a removal, the procedure of the presentation of an address for investigation and proof of misbehavior or incapacity of judge will be determined by the Parliament. Article 124(5). The Supreme Court has held that the judge of the Supreme Court or the High Court can be prosecuted and convicted for criminal misconduct. The expression misbehavior in Article 124(5) in the subclause 5 includes the criminal misconducted as defined as the Prevention of the Corruption Act. Question number 3. Explain the jurisdiction of the Supreme Court of India. The jurisdiction of the Supreme Court of India is of three kinds: original, appellate and advisory. Original jurisdiction. Article 121 deals with the original jurisdiction. By original jurisdiction we mean that the authority to hear and determine a case in the first instance. It has now exclusive in jurisdiction to hear a case which cannot be heard or determined by another court. The Constitution vests the Supreme Court with the original and the exclusive jurisdiction in any dispute between the Union government and one or more states, between the Union government and any state or states of one side or one or more states or to the another. Third, between two or more states. If the dispute involves any question of law or fact on which the existence or extent of a legal right depends, the original jurisdiction of the Supreme Court also extends in the case of the violation of the fundamental rights of individuals, and the courts can issue several writs for the enforcement of these rights. Article 32. It is a unique feature of how Constitution that in principle and any individual can straight away approach the highest court in case of violation of his or her fundamental rights. Second, appellate jurisdiction. The appellate jurisdiction of the Supreme Court extends to the civil, criminal and the constitutional matters. Article 133 of the Constitution provides that an appeal in civil cases lies to the Supreme Court from any judgment, order or civil proceedings of a high court. This appeal may be used in the case of involves a substantial question of law of general importance or in the opinion of high court. The said question needs to be decided by the Supreme Court. Article 134 provides the Supreme Court with the appellate jurisdiction in the criminal matters from any judgment, final orders or sentence of a high court, that is the criminal cases, irrespective of any constitutional question. Appeals can be made to the Supreme Court only by special leave of that court, but is if a particular case involves a substantive question of law as to the interpretation of the Constitution. An appeal can also be made to the Supreme Court if the High Court concerned has certified that question, if such a question is involved. The Supreme Court can entertain and hear appeal of the granting special leave against any kind of jurisdiction of order made by any court or tribunal in any proceedings, and the exercise of power is left entirely to the discretion of the Supreme Court. The advisory jurisdiction. The President may under Article 123 by 1, Clause 1, make a reference to the Supreme Court for its consideration and opinion of any question of law or fact which is which is of such a nature and of such public importance that it is expedient to obtain the court's opinion on it. The President may refer to such a question only for where it is actually arisen from. Also, it appears to the President that it is likely to raise. The President can accordingly refer to the Supreme Court the question whether a proposed bill will be intra vires of the Constitution. Such preferences are heard by the bench of the Constitution, at least 5 judges, and the court allows the procedure of a regular dispute that comes before it. Under Clause 2 of Article 123, the President may refer to the Supreme Court for its opinion and the disputes arising out of any treaty agreement which had been entered into or executed before the commencement of the Constitution. In the case of such references, it is obligatory for the Supreme Court to give its opinion to President. Question number 4. What is meant by the judicial activism and how does it help in the redress of injustice? The judicial activism is use of judicial power to articulate and enforce what is the beneficial for the society in general and people at large. Judicial activism is a layman term for the role of judiciary in initiating the policies of the dispense justice. It is usually through the PIL, but the Supreme Court from time to time has given directions, passed writs, issued orders to redress the injustice either on the request of its own. Mr. Sorabji said the institution of public interest litigation had helped to secure fundamental rights as a living reality for some sections of society. It is known fact that the judicial activism has given us some very good cases, laws and path-breaking judgments, even when led to the revolutionary changes in the society, thus helped the redress of justice like in Bandhu Mukti Morcha or Union of State case. State with an example of the role of PIL in the protection of the right to the people. The Indian judiciary adopted the technique of public interest litigation for the cause of the environmental protection in many cases. The Supreme Court and the High Court shaded the inhibitions against refusing strangers to protect the petitions on behalf of the poor and the ignorant individuals. The basic of ideology behind adopting PIL is that access to the justice ought not to be denied to the needy for the lack of knowledge or finances. In PIL, a spirited individual or organization can maintain petition on behalf of the poor or ignorant individuals. In landmark cases, Vellore Citizens Welfare Firm versus Union of India, Supreme Court allowed the standing to a public spirited social organization for protection the health of residents of welfare. In this case, the territory situated under the river Polar is the Vellore TN were found discharging toxic chemicals in the river, thereby jeopardizing the health of the residents. The court asked the tenantries to close their business. Question 6. Explain the powers and the functions of the High Court. The Constitution provides a High Court for each state. However, the Parliament can be law establish a common High Court for two or more states, a union territory. Just like the Supreme Court, every High Court also gives the entire original and the appellate jurisdiction together with the power to punish for contempt as provided in Article 215. The President of the India appoints the judges and the Chief Justice of a state High Court. While appointing the Chief Justice, he consults the Chief Justice of India and the Governor of the concerned state. While appointing other judges, he consults the Chief Justice of the concerned High Court and also the Chief Justice of India and the Governor of the concerned state. Every High Court under its jurisdiction has power to issue writs for the enforcement of the fundamental rights for any other purpose. Article 226, according to the Article 227, each High Court has powers of the superintendent over all the courts and the tribunals except the tribunals of armed forces. When a High Court finds that any lower court has a pending case which has a substantial question of law, then it makes the case itself for the determination or decide the question or send it back to the same court of determination. The district judges are appointed by the governor only after consulting the High Court. The High Court has an entire administrative control over the district courts and the other lower courts. Regarding posting, promotions and grant of leaves to any person belonging to the judicial service of the state holding any inferior to the post of the judges. Article 235. Thank you and thank you so much. I really appreciate that. Kindly subscribe.